their cases in front of the big shots of the world in the area of cyber law. So now they're going to start the process. So I request Mr. Pawan Dugal to be kind of the chief judge, and then myself, Prashant Mali, can be also with you. You can initiate the proceeding as the kind of the chief judge.
Thank you, Professor Tabrez, and it's a pleasure to be a part of this particular final round of this international moot court competition being organized by GD Goenka University under the thought leadership of Professor Tabrez. I think we are all excited, looking forward to the specific pleadings and the arguments that are going to be put forward by the competing teams. So without further ado, let's get the first team and the first set of speakers.
GDG.
So team first, team code.
GDG-UV06, speaker 1, petitioner.
May I know your time you will take?
I will be taking 11 minutes of my time and 2 minutes for rebuttals.
Okay, and speaker 2, may I know your timings?
Sir, 12 minutes for the submission of the arguments.
Now, team 2, please show your placards and tell me the code.
GDGUV14. Speaker 1 shall be taking 11 minutes for the arguments and 2 minutes for the rebuttal.
Speaker 2.
Taking 12 minutes.
Sorry.
Hello.
Yes.
I'll be taking 12 minutes.
Okay. So you can continue with the further proceedings.
With the prior permission of the bench, the first counsel from the appellant side would like to begin. Your Honor, and may it please the court, I'm the first counsel from the appellant side. Along with my co-counsel, we will be representing the Competition Commission of Digitaria, Hatato, and Texi. And before the bench, we will be arguing on two very important issues. Number one, whether or not QM Digitaria has abused its dominant position. And number two, whether the interim injunction passed by the Dubai High Court is really justifiable. I will be dealing with issue number one, whereas my co-counsel will be dealing with issue number two. Before moving on towards the submission of the arguments, would the bench care for the summary of facts? I take that as a no. Moving on, Your Honor, before moving forward, I'd like to refer you to paragraph number 24 and 25 of the moot proposition, wherein the appellant side today before the court appears for two very important issues. Number one being the abuse of dominant position, which I will be dealing further. Your Honor, before proving and claiming and pointing fingers towards the respondent side as to how or why they've abused their dominant position, the counsel would like to set up certain facts and laws before the court, asserting as to how the respondent side is firstly in a dominant position. Your Honor, if we look at Section 4 of the Competition Act, it's been clearly mentioned that a company is supposed or is in a dominant position when A, it operates independently of the competitive forces in the prevailing relevant market, and number two, if it affects its competitors or consumers or the relevant market in its favor. Your Honor, we say so that QM Digitaria is in a dominant position because of these two very important elements laid down in Section 4(2) of the Competition Act 2002. Your Honor, now I'll be proving as to how it is operating independently of any competitive forces in the prevailing market, in the relevant market of Digitaria. QM, when in Quantaria, had its empire established there. It had so much success that it even had the ability to have a subsidiary organ in Digitaria as well, which clearly proves that QM Digitaria is a company who is able to operate very independently, regardless of the competitive forces that exist within the market. Number two, as to how it affects its competitors or consumers in the relevant markets in its favor. Your Honor, if we look at the fact sheet, it's clearly shown as to how other companies like Hatato and Texi and 10 other companies developing the same product are in the market, and how QM Digitaria, by charging unfair royalty rates, filing a suit against Hatato and Texi, is actually affecting the competition of these particular companies within the ambit of competition laws in Digitaria, which clearly establishes the fact that QM Digitaria now holds a special and a very dominant position in the relevant market of Digitaria. Your Honor, now next element that I like to prove is how QM Digitaria is affecting the relevant market in its favor in Digitaria. If I may refer you to section 2 of the Competition Act, a relevant market has been defined within the ambits of relevant geographic market and relevant product market. If we look at relevant product market, I quote, it means a market comprising all those products or services which are regarded as interchangeable or substitutable by the consumer by reason of characteristics of products or services, their price and intended use. Your Honor, if we look at the 7G technology and how it is not an interchangeable product within the market of Digitaria, it clearly shows as to how QM Digitaria is looking forward or is already exploiting the market in its favor, because it is coming up with a new technology for which the consumers do not have the option to interchange the product, which clearly leads us to the fact that they are using a monopoly within the market of Digitaria, and how consumers now do not have a choice to interchange these products. Moving forward, Your Honor, now as to how we have now that we have established how QM Digitaria has a dominant position within the market of Digitaria, the Council would like to move forward to the fact of how QM Digitaria has abused its dominant position. Your Honor, abuse of dominant position is the conduct which is prohibited by law by a dominant enterprise. Abuse is stated to occur when an enterprise or a group enterprises uses its dominant position in the relevant market in an exclusionarily or exploitative manner. Your Honor, exclusionarily because it is denying the market access to companies like Hatato and Texi, who are willing to go into negotiations and come up with certain technologies which would benefit to people get a larger run. Secondly, exploitatively how? It is because of how QM Digitaria is charging excessive or discriminatory pricing within the ambit of Digitaria. Your Honor, these two instances shows how QM Digitaria has abused its dominant position. Now, with the permission of the bench, the Council would like to move forward as to how exclusionarily or exploitatively the market has been exploited by QM Digitaria. We move on to saying that the disparity in charge of royalty rates between Hatato and Texi from 1.3% to 1.4% is per se the violation of competitions law, section 4 of competition law. We say so because of the following facts. Your Honor, QM Digitaria was a signatory, or rather had complied with the FRAND terms previously with the WTSI authorities, a standard setting organization. Meaning that now QM Digitaria was in a position to charge a more reasonable, fair, and non-discriminatory royalty rates to the parties who approached it to collaborate with other technologies or come to license its patents. Your Honor, we say this because of the fact that QM Digitaria, despite voluntarily signing agreements with FRAND terms, and despite knowing that it was in a position of setting examples to other 7G technologies, was completely in a position abusing its dominant position, despite knowing that it should have not done so. Your Honor, now I'd move forward with the other facts of the case as to how their violation of FRAND terms is quite actually a violation of abuse of position. Your Honor, a FRAND commitment obligates a patent holder to grant license to others on terms that are fair, reasonable, and non-discriminatory. These were the terms that QM, the parent company of QM Digitaria, agreed to follow while licensing its SEPs On top of that, QM agreed to do so while inducing its technology in the standard set by WTSI, which means that QM Digitaria is an example for other minor companies. Now, it's one thing to charge royalty rates, but it's another thing to charge discriminatory and unfair and high royalty rates. Your Honor, if we look at Section 11B of the Patent Act 1917, it's mentioned royalty rates can be charged. We do not deny the fact that they have to charge royalty rates. They can come up with arguments like there has to be compensation for the innovation that had been done, or the facts like their patent rights had to be protected. We agree with that. However, if we look at Section 11B of the Patent Act, royalty rates should be at a reasonable cost or within the profit margin. If we look at the royalty rates that were charged with Hatato and Texi from 1.3 to 1.4%, it's quite actually not very reasonable or non-discriminatory or fair. Your Honor, if the bench has no question, the council would like to move towards establishing a doctrine, namely essential facility doctrine, which the Hatato and Texi meet, and hence QM Digitaria has violated those. If the bench has any questions?
Please proceed.
Yes, Your Honor. Now I'd like to introduce the bench towards an essential facility doctrine, which the court could consider while deciding the case. Your Honor, this is a framework in competition policy whereby a firm cannot refuse to grant access to an essential facility that is difficult to replicate, which it controls to other firms. When a dominant enterprise in the relevant market controls an infrastructure or a facility that is necessary for accessing the market and which is neither easily reproducible at a reasonable cost in the short term, nor interchangeable with other products or services, the enterprise may not without sound justification refuse to share it with competitors or at a reasonable cost. Your Honor, this particular doctrine applies in our case because Hatato and Texi were not in a position to replicate these technologies, and how they were not able they did not have the infrastructure capability to replicate the 7G technology, and hence QM Digitaria, being a signatory of FRND terms set by SSO, was in an obligation to provide these particular patents to Hatato and Texi. Instead, it took the other route by abusing its dominant position. Your Honor, we say so because the facility controlled by a dominant firm in the relevant market proves that it is abusing its dominant position when it constantly refuses to negotiate in terms. In light of these facts, the council would like to introduce a case in front of the bench. It's the case of Shanti Kumar Panda versus Shakuntala Devi in 2004, a Supreme Court judgment, wherein it has been held how refusal to supply or license and utilization of power and dominance to force the competition is abuse of dominant position. Your Honor, when entering the negotiation, Hatato and Texi were unwillingly going towards the negotiation, meaning that QM Digitaria now when it was in an obligation to come up with a more reasonable term so that the other party could negotiate as well. However, it did quite the opposite because it was not willing to negotiate in the first place, which is wrong in itself. An abuse of dominant position has constantly occurred. If the bench does not have any question, the council would now like to move on to proving the elements as to how and why QM Digitaria needs to be held accountable for abusing its dominant position.
Mr. Counsel, you have not proved that why this court has a kind of jurisdiction to hear your case.
Yes, Your Honor. The council will read it out right away. The Honorable Supreme Court of Digitaria has agreed to jointly hear the matter by applying its extraterritorial jurisdiction under Article 139A, Clause 1 of the Constitution of Digitaria and Order 40, Rule 5, Clause 5 of the Supreme Court Rules 2013, due to the matter relevant to public interest and general importance. The appeal from order of the Competition Appellate Tribunal lies to the Supreme Court under Section 53, Clause T of the Competition Act 2002, and appeal from the Dubai High Court order lies to the Supreme Court under Article 133, Clause 1 of the Constitution of Digitaria, Your Honor.
Okay, please proceed.
Yes, Your Honor. That time was over, Your Honor. Would the council proceed forward?
Well, you
Yeah,
done.
you may like to. Yeah, you may like to ask your co-counsel to go ahead with the case.
Yes, Your Honor. Now I'd like to hand over the floor to our learned brother co-counsel to present his arguments. Thank you, Your Honor.
Okay.
Your Honor, and may it please the court, this is Astos Pandey, the co-counsel for the appellant side, that is the Competition Commission of Digital, along with Hatato and Taxi. Today, I will be taking 12 minutes for the submission of my arguments, which is in regards to patent infringement, cybersecurity issues, and invasion of privacy. Your Honor, in response to the petition filed by QM Digital against the W High Court, in the W High Court against Hatato and Taxi, the W High Court first issued an interim injunction against Hatato and Taxi. Then, in a subsequent hearing, it ordered Hatato and Taxi to pay a royalty rate of 1% to QM Digital. Your Honor, first I will be dealing with the issues of patent. On 20th April 2018, Your Honor, QM had applied for patent in Digitalia, and on 20th October 2018, it was successfully granted patent. However, if we see the history behind the development of the patented technology, then it is controversial on very two grounds. Patents first shall be available for any inventions, whether product or processes, in all fields of technology, provided that they involve an inventive step, they are new, and they are capable of industrial application. Your Honor, we stand today before this Honorable Court of Digitalia, pleading that the patent granted to QM shall be revoked, which shall ipso facto dismiss the suit of patent infringement instituted by QM Digital against Hatato and Taxi. Your Honor, the two very controversial grounds on which the QM's patent should be revoked are as follows. The first one being the novelty or the newness. Your Honor, to prevent the double patenting of same technology or product, the condition of novelty or newness must be fulfilled. Novelty is a vital and absolute condition for patentability, which has been incorporated under Section 21L of the Patent Act and which has been upheld in the case of Lallu Bhai Chakubhai Jariwala versus Chimanlal Chunilal. Your Honor, now if we relate this principle with the facts of our case, then it will be more clear. QM and DM had started a confidential joint venture to harness the phenomena of quantum entanglement back in 2015. After QM withdrew its partnership with DM, both companies had asked their employees working on the project to save all the research data in the relative company server. Both the technology developed by QM and DM use the same quantum entanglement method and is only able to communicate when the two devices are physically paired with each other. Your Honor, both the technology have the same system and functional equivalence, as the direct communication is possible only through quantum entanglement method. This clarifies that the technology developed and patented by QM is the same technology which was developed jointly by QM and DM, and QM is not solely the owner of the patented technology. Your Honor, in this lack of novelty is usually referred to as anticipation. And in Digitalia, with the inclusion of definition for new inventions, the test for anticipation now considers absolute novelty. Your Honor, we should focus on the term absolute novelty. The scope of prior art has widened under the Patents Act, because apart from prior publication worldwide and prior use in Digitalia, even prior use outside Digitalia forms part of the prior act, Your Honor. So in order to be a technology to be patented in Digitalia, it should be a new patented throughout the world and it should not be used anywhere in the world. But however, if I may refer you to page 2, paragraph 3, it has been mentioned that on 1st March 2018, DM had already held a big conference in Claudia Quantaria and had announced that it had developed 7G phones successfully. It had also started marketing and launching their phones. Your Honor, this falls under the ambit of Section 31A of the Patent Act, which provides for the anticipation by public display. So the patented technology is already in the press conference, displayed in the press conference. So it is not a novel creation, Your Honor. On this grounds, the patent should be revoked. Your Honor, the second ground is the
Counsel, can you say that because they have not disclosed the entire novelty, they have not disclosed the inventive step, simply announced technology. So there is no disclosure of the actual research, the inventive step that is required to get a patent. So how you can say that they have disclosed to the public?
Your Honor, the council meant that they displayed that the technology was developed and they had started marketing and also selling those technologies in Quantaria and Digitaria as well. Your Honor, now coming to the inventive step. Inventive step is another condition for granting patent, which shall be illustrated under section 21JA of the Patent Act. And if I may refer you to page 3, para X VII, DM had launched the first ever 7G phone in Digitaria along with rest of the world on April 5, 2019. Your Honor, it is to be noted that Hatato, Texi, and 10 other companies also had started marketing and launched their 7G phones. Your Honor, this shows that the technology did not meet the criteria of non-obviousness, because if it had met the criteria of non-obviousness, it would be only the company which will be manufacturing the products. But here, 10 companies, Your Honor, not one, not two, there are 10 companies manufacturing the same product and selling it, which is in contrary to the provisions of this inventive step, and hence the patent shall be revoked. Your Honor, now
there is a fact is silent on this point. You are just speculating that there was no invention, and because of the 10 companies producing the same item, you cannot say it was not an obvious thing. So it's only a speculation, because fact is silent on this point, because these 10 companies have somewhat different technology for same product.
Sir, Your Honor, thank you for your question. It has been mentioned in the fact sheet that all the companies, QM Digitaria, Hatato, Texi, and 10 other companies had started marketing and launched their 7G phones with inbuilt meeting app too. So we can assume that all these companies are selling the same product of the same technology, and it does not contravenes with the condition of non-obviousness of the patent rights, Your Honor.
It says that they have same product. So a product with the meeting kind of the application is the same product, but all the company may have different process to find the same product, because patent can be granted for process as well as for the product. So they may have different process, but fact is silent on this point. So how you can speculate that because of this particular fact, there was no obvious thing.
Even if we take out Hatato, Texi, and 10 other companies, still DM and QM use the similar technology which has been mentioned in the fact sheet, and the functional equivalence of both the technology is same, as they use direct method of quantum entanglement, and the communication is possible only when the two devices are paired together, which means that they use similar or almost same type of method of communication in both of their companies. And in case of Your Honor, Biswanath Prasad Radhe Syam versus Hindustan Metal Industries, it has been illustrated that the improvement or combination must produce a new result or a new article or a better or cheaper article than before. So just a mere modification does not amount to new technology, and hence it cannot be patented, Your Honor. Your Honor, now moving.
I think you are citing very old case. Because latest we have at least one inventive step. There's a lot of debate what is inventive step right now. Can you define what is an inventive step to get a patent in technology?
Your Honor, inventive step has been defined under section 21JA of the Patent Act. If the bench permits, I would like to read out the.
Yeah, please read.
Yes, Your Honor. Inventive step means a feature of an invention that involves technical advance as compared to the existing technology, or have economic significance, or both, and that makes the invention non-obvious to a person skilled in that art. Your Honor, suppose if I produce a hanger of a bigger size and the other companies produce the similar type of hanger but that of smaller size, they cannot be granted a patent, because we know it is obvious to us that we can produce a hanger of any size that is possible, that is in the market, but we take a general idea and produce those hangers. So in this case also, Your Honor, they use the same research method joint developed by the two companies, and their functional equivalence is almost similar. Both use quantum entanglement method, and only the two devices shall be able to communicate when they are paired with each other. This clearly illustrates that the technology was same, and just a mere modification cannot amount to a new patent, Your Honor.
Mr. Consul, the example of citing about the design example, because if they are citing the example of the hanger, of the same kind of the design hanger cannot be copied, but the hanger can be of different kind of materials and process, and it may more strength, more stamina, more durability, and more life than the other kind of the hanger. So even the two hangers may be different in size, but the quality and the process of the finding and the kind of the durability of those hangers can be different. There will be different question of the design also. My question was that regarding the process, they may have different technology to find out the particular product. And we're not, I was just speculating that they have no inventive step, and that's why they should not be allowed to get the patents. Okay, you can proceed further.
Thank you, Your Honor. Your Honor, and the High Court, with due respect, the W High Court has erred in making its decision, as it has ignored some of the precedents laid down by the Honorable High Court and Supreme Court, in which it has been ruled that where the patent is of recent origin and its validity has not been tested, the court should not grant injunctions where infringement is alleged. Your Honor, the alleged infringement by QM Disteria in the W High Court, and the court granted an interim injunction which is against this rationale, which has been mentioned in the case of Manika Thewar versus Star Polar Works, Surendra Lal Mahendra versus Jane Galzers, National Research and Development Corporation versus Delhi Cloth and General Mills, Your Honor. So today we stand before this honorable court to take into account this precedents and hear that the interim injunction given by the W High Court is against the law and shall not be upheld. Your Honor, with the bench permission, I would like to move towards the second argument and sum it up in really quick time. Your Honor, in March to June 2020, when the world was fighting against the COVID-19 pandemic, QM Disteria, Hatato, Taxi, and 10 other companies started marketing and launched their 7G phones with inbuilt meeting application named Toom. Your Honor, it is to be noted that as soon as Hatato and Taxi launched their 7G phones, the QM Disteria instituted a lawsuit against them for the breach of privacy and cybersecurity. Your Honor, if I may refer you to page 3, paragraph XVI, line number 4, it has been clearly stated that the Toom application was present in phones of QM Disteria, Hatato, Taxi, and 10 other companies. Yet, Your Honor, QM Disteria instituted a lawsuit only against Hatato and Taxi. We agree that if the app invades the privacy of the users, if the privacy of the users are in a dangerous state, then the app should be banned. The mobile phone should be banned, Your Honor, but not only of Hatato and Taxi, but of all those 13 devices, Your Honor. As my time is up, now I would like to move towards the prayers, if the bench permits. In the lights of issues raised, arguments advanced, and authorities cited, may this Honorable Supreme Court of Disteria be pleased to declare that QM Disteria has abused its dominant position by charging unfair royalty rates, violating FRAND terms, and the interim injunction imposed by W High Court on Hatato and Taxi is not justifiable, and or pass any other order that it seems fit in the interest of justice, equity, and good conscience. For this, the counsel for the appellant shall humbly pray. Your Honor, thank you. It was pleasure pleading before this court.
Thank you for your service. Any of my brother judges who don't have any questions? If no, then we could proceed forward to the other party, please. The other counsels.
Greetings to the Honorable Bench. Counsels on behalf of respondents shall refer to the bench collectively as Your Lordships. Your Lordships, Counsel 1 on behalf of respondents shall be dealing with the issue pertaining to interim injunction, while my co-counsel shall argue the stance on abuse of dominant position. Your Lordship, before the counsel moves on to their submissions, I would like to address a few points or a few grievances raised by our learned opposing counsels. Your Lordships, to begin with, the jurisdiction that this court has, Your Lordships, the opposing counsels have erred in seeking jurisdiction under Article 133A of the Constitution of Digitaria. Your Lordships, if I may read the same for Your Lordships' convenience, Your Lordships, Articles 133 and 134 deal with a certificate which is to be provided by the High Court in order to appeal to the Supreme Court. Your Lordships, in the present case, the Supreme Court of Digitaria has jurisdiction under Article 136 of the Constitution of Digitaria, as an interim order is included under Article 136. Furthermore, Your Lordships, they have erred in their written submissions by seeking jurisdiction of this court under Section 40 of the Competition Act. Your Lordships, Council would like to state that Section 40 of the Competition Act was repealed by amendment in 2007. This court has jurisdiction under Section 53T of the Competition Act. Your Lordships, to proceed further with regard to the validity of the patent, Your Lordships, regard be had to the clarifications issued to the Moot proposition. Your Lordships, clarification 1 clearly states that the validity or the timeline of the patents is not in dispute. Hence, the patents are very much valid and are not to be disputed. To begin with the submissions, Council would like to address the issue on interim injunction. Your Lordships, interim injunction granted by the Dublin High Court is valid on 2 grounds. One, pertaining to the tomb application, and second, pertaining to the patent infringement. Your Lordships, with regard to the tomb application, regard be had to the fact that in Moot proposition paragraph 20, it is provided very clearly that the users of Hatato and Taxi complained of privacy, cybersecurity, and safety breaches in the tomb application. Your Lordships, now we understand the fact that the tomb application is an inbuilt application in Hatato, Taxi, the respondent, and 10 other phones. Your Lordships, however, we have raised this concern before Your Lordships of privacy issues because only the users of those 2 phones have complained of issues. Your Lordships, if Your Lordships come to a conclusion that the tomb application in general has a privacy issue, the respondent has no issue whatsoever. Respondent would not want to jeopardize or threaten the sovereignty of this country or to violate the rights of the citizens. We understand that right to privacy is a fundamental right, as has been provided in K.S. Puttaswamy versus Union of India by your honorable Lordships. Your Lordships, furthermore, what must be noted is that under the IT Act, there have been violations, grave violations by Hatato and Taxi with regard to their tomb application in their handsets. Your Lordships, the IT Act provides a secure environment, provides a legal secure environment for paperless communication. Now, we must understand the fact that in the present case, when dealing with handsets, it is a paperless communication and we are in a time of a pandemic. No one would want to take advantage of helpless people sitting at home who cannot or who do not have recourse to remedies, swift remedies currently. Your Lordships, in the present circumstance, there has been a grave violation of rules 5 and 6 of the IT rules of 2009 pertaining to collecting and storing of information, as the handsets, Hatato and Taxi are intermediaries in the present case, Your Lordship. Your Lordship, we do not know of the kind of or the nature of contract that Hatato and Taxi have with Tomb. However, because the users have complained of such issues, we have to make them liable because despite the knowledge of these complaints, they did not take any action. Your Lordships, furthermore, you are sense a concern, Your Lordship?
Let me pause for a minute. You said that they are not going to be liable. Can I seek your indulgence to Section 21W of the IT Act and Section 79 of the IT Act? Now, once you yourself say in your arguments that they are intermediaries, then they are automatically entitled to statutory exemption from legal liability under Section 79(1) of the IT Act. So how would you want to counter this particular proposition?
I understand your concern, Your Lordship. However, in the present case, being intermediaries, they hold certain liabilities under the IT rules. One being the rules on collecting and monitoring of information of 2009, and second being the IT interception rules, rule number 20 and 21. Wherein as intermediaries, they are responsible for checking and handling the information that comes their way and have to maintain secrecy and confidentiality. If I've addressed Your Lordship's concern, I would like to proceed to my arguments.
Please proceed.
Your Lordships, furthermore, if we come to the question of patent infringement and injunction, Your Lordships, in the present case, there has been a patent infringement and the injunction for the same is very much valid, as has been held by Dublin High Court. Your Lordship, this injunction is valid on 2 grounds. As 1, appellants are not willing licensees, and 2, the balance of convenience lies in favor of respondent, which is QM. Your Lordships, appellants are not willing licensees in the present case. Had they been willing, the interim injunction could have very much been challenged. However, they have themselves said that they left the negotiations due to the high demand of royalty. Your Lordship, what must be noted at this fact is that in Siswell versus Heyer, which is a German case, which has been adjudicated in May 2020, very recently, it has been held that a mere or the hollow statement of being a willing licensee is not enough. There has to be a real and visible engagement. Regard be had to the Moot proposition, paragraphs 12 to 15, which Your Lordships may have on page number 3. Your Lordships, it will be found that appellants engaged in negotiations with respondent. However, just due to the demand of a royalty, they left the negotiations. Your Lordships, one, there was no counter offer made by the appellants. And second, they did not show the willingness by approaching an independent authority, which in Siswell versus Hare has been held to be a determinant of a willing licensee. Your Lordship, had the appellant made a counter offer, or had the appellant initiated the proposal of going to an independent authority, which the respondent took the appellant into the Dublin High Court, the appellant would have been treated as a willing licensee. However, in the present case, the injunction is valid as the appellants are unwilling. Your Lordship, a simple example of this would be the council going to a shop and asking for a pencil. Now, if the shopkeeper refuses to sell that pencil, or if the shopkeeper says a particular rate, and I as a person refuse to take it at that rate, I cannot steal it. In the present case, what the appellants have done amounts to stealing our patent. A lot of effort and research goes into the making of a patent or making of an invention. It is a result of extensive research and development, and the same has been violated by appellants. Furthermore, Your Lordships, in Huawei versus ZTE, it has been held that the mere statements of being willing, or the mere statement of coming into a negotiation and leaving it midway, is not a determinant of a willing licensee, and an injunction can be issued against such parties if they violate the patent. Your Lordships, this has been replicated in the present case, which is why we have sought Your Lordship's assistance in order to uphold the injunction which has been granted by the Dublin High Court. Furthermore, Lordships, arriving at the balance of convenience. Now, balance of convenience lies in favor of a party which is likely to suffer a graver loss if the relief sought is not granted. In the present case, Your Lordship, the loss that the respondent is suffering, which is the denial of royalty or a compensation for this research and development, is not quantifiable if the appellants continue to violate its rights. Your Lordships, what is to be noted in this is that in the present case, interim injunction is an urgent relief in order to prevent other licensees from, or in order to prevent other manufacturers from violating the rights of the patent holder. Furthermore, Your Lordships, royalty in the present case in FRAN terms, there is no jurisprudence on FRAN terms which says that the FRAN terms have to be identical for all licensees. We understand that FRAN terms have to be on a level playing field. But however, what is important to be noted is that they are not to be identical. They are to be fair and reasonable, which the respondents agree, which is why we agreed to give all our licenses to WTSI. Agreed to get into an arrangement with WTSI, which is the standard setting organization. Now we understand, Your Lordship, we understand the appellant's concern when they say that the royalty could be high, which is why we stated in front of Your Lordships that the appellants were not willing in the first place. They could have given us a counter offer, or they could have taken us to an independent authority. We did not refuse to that. Furthermore, Your Lordships, in the present case, lifting or not upholding the interim injunction would set bad precedents for other manufacturers to violate our rights. What is more important to be noted in this fact is that our hard work has gone into making that research and development, as can be found in the Moot proposition. Furthermore, Lordship, this is a process patent. Our various component technologies have been patented, which is why the appellants cannot come forward and say that they have not replicated our technology when they have gone on to make patents on patents and are challenging the validity of a patent by saying that it is merely new. Your Lordships, our patents are dated to 2018. However, we started manufacturing the phones, or however the phones came into the market in 2020. And the timeline, the Moot proposition is silent with regard to the timeline of the negotiations or the timeline of the present case, which is why the appellants cannot assume facts and create their own timelines. Your Lordships, to conclude my arguments, we submit to the jurisdiction of this court, and we respect the decision of the Dublin High Court to set royalty to the tune of 1% on the final sale value, showing our eagerness to give our licenses to the. Do I sense a concern, Your Lordship?
Yes, please. Can we have the other co-counsel if you're finished?
May I just conclude? Your Lordships, we submit and we respect the decision of the Dublin High Court, as we are willing to give our license, and we are in no way exploiting the appellants, or we are in no way violating our commitments, which is why the interim injunction in the present case is very, very much valid in law, and it is needed as an urgent relief to prevent others from violating our rights. and to prevent the market being exploited. Much obliged.
Can we have the other co-counsel, please?
Greetings, Your Lordships. I'm speaker number 2, and I'll be arguing issue number 2 on behalf of Team Code 14. I'll be addressing the issue pertaining to dominance as has been alleged to be done by QM, my client, by the appellants in the present matter. Your Lordships, prior to moving with my contents of the arguments, I would like to point out certain inconsistencies that cropped up in the submissions of speaker number 1 and speaker number 2 of the opposing team. Here, Your Lordships, on one hand, the speaker number 1, while arguing dominance, contends that DM is not a substitute or an alternative to QM, and that is why QM is dominant. That is what they want to hold against me and to establish my dominance and resultantly establish my abuse. However, Your Lordships, then speaker number 2 goes ahead to argue that, goes ahead to erroneously challenge the patent that was given by invoking the ground of absence of novelty. This appears on page number 11 of their written submission as well, Your Lordships, where they contend absence of novelty and therefore resultant functional equivalence of DM and QM. Your Lordships, in my opinion, their stance has not been clear all throughout the submissions, where on one hand, according to their convenience, they assume that it is a substitute, and in accordance with their convenience, again, in accordance with the second issue, they assume that they are not functionally equivalent. So that, Your Lordships, must be noted in the interest of the respondent. Your Lordships, now I will be proceeding with the contents of my argument. Your Lordships, here while addressing the issue of dominance, I would be following a two-pronged strategy. Under the first prong, I will address how QM did not hold a position of dominance in the relevant market of 7G smartphones in Digitaria. Secondly, Your Lordships, I would be arguing that arguendo this honorable bench is to come to the finding that QM was in fact dominant. I will be arguing then that in pursuance of that position of dominance, we have not committed any act that would be taken as an abuse under the Competition Act 2002. Your Lordships, now I would be beginning with the first leg of my submission, which is no absence of dominance in the relevant market of 7G smartphone devices in Digitaria. Your Lordships, here I would like to first of all quote para number 8 of the memorial, 8 of the Moot proposition, where the WTSI said that owing to the functional equivalence of DM and QM's technology component, it was free to go ahead making its technology standard with either of them. Thus, Your Lordships, incorporation of QM into the WTSI did not put DM at any disadvantage, because WTSI, before making the standard, made it very clear that incorporation of any one of those brands would not put the other into any disadvantage. Second, Your Lordships, arguendo, we are to assume that we were in fact in a better position as compared to DM on account of us being a part of the standard. I would like to cite the case of I would like to cite the case of Illinois Tools, which is a US 2006 case, where it has been held that just because there is a patent, it does not necessarily confer market power to the patent holder. Here, Your Lordships, I would like to rely on the chairman of the Federal Trade Commission's view, where he holds, which appears on page number 9 of my memorial, that a patent which has been incorporated may face stiff competition from even non-standardized products, which, Your Lordships, is my submissions on account of DM being a functional equivalent in the present matter. Your Lordships, this makes a case of alternatives available, which is a criteria which the bench must look at in ascertaining dominance under section 20, subsection 4, clause G. So, Your Lordship, this section provides that if substitutes are available, an enterprise cannot be said to be dominant. And my submission humbly is that on account of the arguments I raised earlier, DM is a valid substitute and alternative under the Competition Act, and that is why we are not in a position of dominance. Arguendo, I would like to move on to the second limb of my argument, where I say, assuming, let's for once assume that we were in fact dominant, I would be countering the 3 allegations that have been made against us. Number 1, charging of royalty rates which were allegedly discriminatory and unfair. This, Your Lordships, I would be countering under section 4(2)(a)(2), which pertains to unfair and discriminatory pricing. Second allegation against us, I think it was not raised, but I would still like to counter that, is the signing of an NDA that we required them to do. This I will counter again under section 4(2)(a)(1), Your Lordships. Thirdly, seeking and securing an injunction for patent infringements, Your Lordships. This again, I think, was not raised properly, but I would be countering this under section 4(2)(c), which pertains to denial of market access. Your Lordships, firstly, I would be starting with section 4(2)(a)(2). Herein, I will establish how the royalty rates that we charged them, being to the tune of 1.3 to 1.4%, were not violative of either FRAN terms or the Competition Act. Your Lordships, here I would like to refer the bench to para 14 of the Moot proposition. Here, Your Lordships, the Moot proposition categorically mentioned the stance taken by the appellants during negotiations. They said, we are leaving negotiations because it would hurt our profits. Nowhere did they mention that it is violative of FRAN terms or any other plea that was. So it is now only a belated plea of violation of FRAN terms. This argument I would like to counter by the case of Erickson versus D-Link, which appears on page number 9 of my memorial, where the court has expressly stated that a royalty rate does not become violative of FRAN or RAND terms only because the licensee believes the royalty rate to be unreasonable. Your Lordships, now second, I would be countering how these royalty rates were not unfair on 2 grounds. Number one, the percentages were well fine. That is because, Your Lordships, the CCI, or which is in paramateria to CCD in the present matter, Competition Commission of Digitaria, has held expressly again in Erickson versus Intex, where it charged a royalty rate of 1% on the final sale value of handset, Your Lordship. Then we were very close to charging 1.3 and 1.4. Here also I need to mention, Your Lordship, that it was only an initial offer, not the final rate that we charged them, subject to a counter offer or us approaching another tribunal. Second, Your Lordship, it could have well again be charged on the net sale value because, Your Lordships, here I cite the case of the Dublin High Court or the Delhi High Court in Erickson versus Intex, where it upheld an American case of CSIRO versus Cisco and rejected the argument that the royalty rate must be based on the chipset and went ahead determining a royalty rate of 3.5%. I repeat, Your Lordships, 3.5% on final sale value of handset. Next submission, Your Lordship, would be how these were not discriminatory. I think my co-counsel has very well pointed out that non-discriminatory limb of FRAN does not imply uniform pricing, Your Lordships, and considering the minimal difference of 0.1%, I would like to cite the case of Siswell versus Hire, where it has been categorically held that a previously concluded license, here we must note that it wasn't even a concluded license. Yet again, I would quote, a previously concluded license cannot be the benchmark of subsequent licensing negotiations. Your Lordships, further, now I'll be establishing there was no violation of 4.2A1 with regard to the obligation of a non-disclosure agreement. Your Lordships, in Erickson versus Intel, again, the Dublin High Court has recognized an NDA as a sine qua non of patent licensing negotiations. Interestingly, Your Lordships, Erickson was also a case of SEPs, and that is why it has been very well recognized that it is valid, let alone being an abuse, which is totally on the flip side of the coin. Your Lordships, thirdly, I would be arguing how there was no denial of market access in us seeking a bona fide injunction against an unwilling licensee. Your Lordship, this would be a rebuttal to invocation of Section 4.2c. Had it been invoked, it has not been by the present appellants. Your Lordships, the Supreme Court, the American Supreme Court's Noll-Pennington doctrine has expressly said that a bona fide request of an injunction by a patent holder cannot be held to be an abuse of position of dominance. Here, Your Lordships, again, I would like to cite Huawei versus ZTE, the opinion of the Advocate General, particularly in this case, where he goes ahead holding that the request for an injunction against an implementer, although ostensibly negotiating licensing terms, but when he does so in a manner which is purely tactical or dilatory or not serious, will not be held to be an abuse, which is the present submission, Your Lordships, merely approaching a patent holder and then just leaving the conversation midway without offering any other counter offer was purely not serious, and which makes the appellants in the present case unwilling licensees. Your Lordships, lastly, I would like to rely on Commissioner Joshua Wright, who is the Commissioner of the Federal Trade Commission, when he holds that it is a settled position now that an SEP holder does not violate antitrust laws by simply seeking an injunction. Your Lordships, having regard to all these submissions, I would now like to proceed to my prayer. Therefore, in the light of the facts of the case, issues raised, arguments advanced, and authorities cited, it is humbly prayed that this court declare that, number one, the interim injunction and the subsequent order of vacation that was passed by the Dublin High Court was totally reasonable and good in law. Number two, similar was the case with the decision of the Honorable CAT, and it is not liable to reversal. Your Lordships, in the light of the arguments advanced, the Honorable Bench may pass any other orders in the interest of justice, equity, and good conscience. Much obliged, Your Lordships. It was a pleasure to argue before the bench.
Thank you, Ms. Counsel. Any of my brother judges have any questions for the counsels? Well, thank you to the counsels for both the parties for elucidating the matter in issue. On behalf of the bench, must compliment all the counsels for having put in such remarkable effort in assisting the bench. Your ability to dissect and bisect different complicated issues from such a complicated set of the moot court problem was indeed very appreciable. I particularly liked the passion, the commitment, and your ability to go ahead and swing and bring in different elements into your respective arguments. It was indeed very, very good experience trying to see how, as counsels, you have gone beyond just the scope of mere academic input and have sought to analyze and put in practical elements while relating some of the issues that you've talked about in the course of your arguments. Very well appreciated, and thanks to all the counsels for assisting the bench in such a remarkable manner. Congratulations for your work. Over to comments to my other panel fellow judges.
Prashant, I think you have muted yourself. Prashant, please unmute. Prashant, please unmute yourself. Please unmute. You're not audible.
Yeah, am I audible?
Yeah, please.
So it was nice to hear about various sections compared, and more specific, the case law cited and analyzed before the bench. So the bench, adjust the matter. The life of the bench becomes easier. So best of luck, and we can proceed with the further proceedings.
Any rebuttals are there? Any party want to rebut anything?
Yes.
Any rebuttals you want to have? Anybody?
Yes, Your Honor.
You want to rebut any points?
Yes, Your Honor. With the Honor's permission, the counsel would like to begin.
Yeah.
Your Honor, I'd like to cite the same case of Micromax Informatics Limited versus LM Ericsson, wherein it has been held. In a licensing agreement covering SEPs, the licensor cannot charge different royalty rates or offer different commercial terms to the licensees belonging to the same technologies, meaning that despite the fact, knowing that they were supposed to charge fair and reasonable. Your Honor, I'd like to enlighten on the fact, again, on the section 11B of the Patent Act 1917, wherein it has been clearly mentioned how royalty rates need to be charged looking at the profit margin and at a reasonable rate. What do we mean by reasonable and profit margin? Meaning that we have to consider the profit margins of the other party who is in the negotiation as well. In this case, QM Digitaria, without considering the fact that Hatato and Texi, who themselves had approached QM Digitaria, did not consider these particular articles or any of the sections within the favor of Hatato and Texi. Adding on to that fact, of how our respondents had mentioned, the counsel had mentioned section 14. No, the counsel had mentioned section 53T while in the pleadings. Perhaps in the memorial, it could have been wrong. I'd like to apologize. But during the submission, the counsel had mentioned section 53T, if the bench has noticed. Next, we would like to move on to the fact how willingness of the agreement, how the respondent sides have manipulated. Your Honor, I'd like to refer you to the Moot proposition where it is clearly mentioned how Hatato and Texi have reluctantly moved on to the negotiations, meaning that QM Digitaria, being in a dominant position, had somehow manipulated these two companies to come into their negotiations, negotiate on their terms, and leave without a licensing agreement. Your Honor, QM Digitaria has clearly abused its dominant position despite knowing that it had signed the WTSI FRAN terms. What do we mean by WTSI FRAN terms? It means that the particular company, whoever is a signatory of FRAN terms, needs to consider the factors of the other parties who are going to move towards licensing agreement with the party who is a signatory of the FRAN terms as well. If the counsel permits, could the counsel have 1 more minute to roughly sum up a judgment? Yes, Your Honor. So in a memorandum of SEPs done by J. Gregory Siddharth, a chairman of Criterion Economics LLC, who has advised the Ministry of Commerce and Industry in India, he has mentioned how SSO will compensate the companies of the FRAN term signatories or the companies who have agreed to the FRAN terms. If they are suffering a loss, SSO will guarantee reliable compensation if they are going to charge reasonable royalty rates. Your Honor, with these facts alignment, it's clearly visible that QM Digitaria has abused its dominant position and how the patent rights should be revoked and how the appellant side should win the case today. Thank you, Your Honor.
Okay, other side, Nisa rebuttal.
Indeed, Your Lordship. Your Lordship, counsel would keep it limited to the rebuttals. Counsel for respondent can understand the grievance of the appellants by looking at the amount of stress that they're taking by laying the stress on their terms. However, Your Lordship, wrong does not become right by doing the same. We must point to the fact that the willingness that they're talking about, the counsels, the appellants never entered into negotiations, never entered into proper negotiations. They left the negotiations midway without even telling the respondent what is troubling them apart from their profit-making margin. Now, Lordship, the appellants cannot rely on the royalty rate again and again when during that stance, as has already been reiterated in paragraphs 12 to 15, their main concern was their profit motive, which is why they were not agreeable to our royalty rates. They had no problem whatsoever with the FRAN terms, or they had not raised any objection with the FRAN violations. Furthermore, Lordships, the Micromax versus Ericsson case that my learned opposing counsel has cited, Your Lordship, we must note the fact that in light of the facts of this case, limiting our scope to the facts of this case and looking at the facts of the present case, we must see that in the present case, there was unwillingness on part of the appellants. And in the present case, we have not abused any dominant position as we were not dominant in the first place. And even if we were, there was no abuse as has already been stated in our arguments, which went on for quite long. And we don't see any concern now, any new or fresh concern being raised by appellants. Much obliged.
Okay. Any question?
This dominant and reasonable, these two words, when frequently used in any. Am I audible?
Yeah, please go ahead.
Yeah. To counsels, when you use dominant and reasonable, these has a varied interpretation. And when you keep using these words for arguing, you put a lot of onus on the bench instead of, coming from your arguments and making the bench to decide. If you're using such words in your arguments, then it is always better to substantiate what do you mean by it and what is a decided case law based on this. So if you're fighting on words which have varied meanings, or varied interpretations, it's always better to stand on a case law and not diverge, on very much on English, because we will not interpret English. The bench will not interpret English. We are here to interpret the law. Thank you.
Regarding the FRAN conditions, that it was not that intentionally they wanted to the other party to go back, so they will be able to dominate the market.
Your Lordship, is your question addressed to the respondents?
To you, your team. Yeah, respondents.
Your Lordship, could you please repeat your question?
Because ultimately the negotiation could not go ahead, and then parties actually bifurcated. It was it shows that the QM may be intentionally trying that not to agree and try to capture the market and also try to charge the very high royalty. It was actually shows very intentional.
Your Lordship, to address your concern, regard be had to the Moot proposition where QM Digitaria agreed to license all its SEPs on FRAN terms to WTSI. Your Lordship, this was done in public interest so that other licensees can obtain a license from QM Digitaria in order to incorporate its technology into their products. Your Lordship, furthermore, to address your concern on FRAN terms, there is no particular legislation on FRAN per se, neither in Digitaria nor abroad, which is why we rely on international practice and what the cases have been holding so far. Your Lordship, if that addresses your concern,
Okay. Thank
much
you.
obliged. Much obliged.
Would the council answer the question mentioned by our honorable judge before the respondents? The definition of reasonable compensation and reasonableness and dominance. Would the council be permitted to define the term reasonableness? Yes, Your Honor. So if we look at the case of Panduit Corp versus Stalin Bros Fiberworks, it's been held that reasonable royalty is an amount which a person desiring to manufacture and sell a patented article as a business proposition would be willing to pay a royalty and yet be able to make the patent article in the market as a reasonable profit. Your Honor, the profit element here needs to be balanced on both the sides. So what we mean by reasonable is that at the end of the day, when the company who is paying the royalty rates also does not go through a loss, meaning that their profit margins would be preserved, and the other party who is to be paid, their profit margins would also not be hampered. So this is what we mean by reasonable rates as held by case laws. Thank you, Your Honor.
Thank you. I think this has been a very interesting and invigorating session. We were able to listen to arguments on both the sides. And thank you, counsels, for presenting various facets of your arguments. If you take a note of, and there's no other stuff, then I think we would like to, the bench would like to then deliberate
Okay.
on the judgment. Over to my brother, Judge Professor Kapil.
Okay. So I think the speakers, both teams can log off. Now we can then discuss about the evaluation part. So yeah.
Much obliged, Your Lordship.
Much
Thank you,
obliged,
everyone.
Lord.
Yeah.
Thank you, Your Honor.
Mohit, we can now stop the live webcast on the Facebook. Mohit, you are there? Mohit Tarola? Mohit, you are there?
So let me contact Pankaj, sir.
You call Mohit because we have to stop on the live webcast now. We are going to discuss about the evaluation part.
Yes, sir, I'll contact.
Sir, I'm calling Mohit.
Okay.
Company.